Alina Habba is renewing her request for a mistrial. We're back in the E. Jean Carroll case, New York, Judge Kaplan presiding. And remember, on day 3 and on day 2, Alina Habba was really getting into it with Judge Kaplan. And at one point, we learned in the testimony that this accuser, E. Jean Carroll, aka Miss Bergdorf, who alleges she got Bergdorf in the dressing room at Bergdorf's, she admitted on the stand that she had deleted evidence. Remember, this is a case for defamation and damages. And she said, well, a lot of people sent me death threats. When Donald Trump started speaking out against me, calling me a liar, they started making mean tweets about me. And Alina says, oh, do you have those mean tweets that were all delivered to your DMs? Do you happen to have those emails? Do you happen to have those Facebook messages and so on? And she said, no, I deleted all of them. And she said, well, that's very convenient because we demanded those via subpoena. We'd like to see them. And she said, well, I don't have them. We thought, isn't that convenient? So she moved for a mistrial. Judge Kaplan told her, denied, and told her to sit down and shut up. And so she submitted this letter in. Very beautiful motion. Let's read through it. You see, from the office of Abba Madeo, from Alina Habba to Honorable Lewis Kaplan, from the Southern District of New York. She's the managing partner over there, admitted in 3 states. Gosh, so smart too. Filed a 7-pager. The case is Carroll versus Trump. You see, going to the Southern District of New York. Miss Habba writes, Dear Judge Kaplan, now this office represents President Donald Trump. Now this letter is submitted to renew a demand for a mistrial that I made in your courtroom a couple days ago. Or, in the alternative, if you're not going to do that, we're demanding that Roberta Kaplan and E. Jean Carroll be precluded from seeking damages related to death threats that were purportedly made to her, and all testimony that was related to these so-called death threats be stricken from the public record and from the record of this trial, or in the alternative, that the court include an adverse inference charge against her because E. Jean Carroll deleted data. It was related to her willful violation of her discovery obligations, and she spoiled the relevant evidence that we need for our defense. As Your Honor is aware, during cross-examination on January 17th that we covered here, plaintiff E. Jean Carroll was specifically asked about the deletion of emails, which bear direct relevance to this instant action. Now, in response, E. Jean Carroll on the stand, she admitted that she deleted multiple email messages pertaining to death threats that were made to her. Now, here's what the trial testimony that was provided by her sounded like, Judge Kaplan, in case you forgot. Question from Miss Habba. E. Jean, now you said that you received threatening messages in your testimony. Remember saying that today, correct? Yes. And you deleted those messages? Yes. And do you know what happens when you delete a message from your inbox? Well, it goes into the trash in my computer, and then the trash is emptied automatically every 30 days, I think. Oh, so you knew it was going to be deleted. Did you ever delete the emails from the trash section of your email? So like you deleted it and then go in and delete that? I probably did. So your testimony, E. Jean, is that you deleted the messages and then they went to the trash and then you went into the trash and then you deleted the trash as well. Is that correct? Well, I didn't go into the trash. I just periodically empty my trash in my computer because it's an old computer and it tends to slow down if I have a lot in the trash. Did you stop deleting those threatening messages at any point, Miss Carroll? Yes, I did. Well, what was that point? Actually, I went on deleting most of the replies. I stopped right around the second lawsuit, the one in May, I stopped. So the first trial we had was when you stopped deleting them. Is that right? Well, no, that is correct. I don't remember deleting any around that time or since then. Habba says, I'm confused, Miss Carroll. You stated in your testimony today that you receive death threats daily. Is that correct? Well, not daily, but often. Okay, so often. And you deleted those messages all until you were in the middle of trial? Is that your testimony today? No. Okay, so please explain to me what you meant by that, Miss Carroll. The court Kaplan jumps in. Explain what she meant by what? Habba says, well, when did you stop deleting the death threats, E. Jean? I generally got rid of many of the replies on Twitter and on Facebook. I would just delete. I did not delete my post. I just deleted the replies. I hadn't realized how many death threats there were in my private messages. Miss Carroll, my question is, thank you for that. When did you stop deleting them? The messages that you just spoke about. When did you stop deleting them? We've been litigating this for years. Probably 2023. A lot of deleted messages here. Curious. So Alina says, all right, Judge, listen. Now, based upon that trial testimony that you just heard, E. Jean admitted to deleting evidence that was clearly related to this litigation in direct violation of the rules of civil procedure. Now, the rules say that anything that's electronically stored be preserved for litigation. Now, she acknowledged, E. Jean, under oath that she violated the rules. Despite being served with a subpoena in connection with this action, E. Jean Eugene failed to take reasonable steps to preserve relevant evidence. In fact, she did much worse. She actively deleted evidence, which she now attempts to rely on in establishing her damages claim. She says these are so hard and I'm in so much pain and I deleted them all. Now, accordingly, it is beyond dispute that plaintiff's failure to comply has caused significant prejudice to Donald Trump. And so now Alina says, I am renewing my request that I previously made on the record for a mistrial. I said, Your Honor, at this moment, I feel I have to ask for a mistrial. The witness, Eugene, has just admitted to deleting evidence herself, which are part of her claim of damages, and I haven't seen them. She has no evidence of them. She hasn't turned them over, and they're gone. And now she wants my client to pay millions of dollars for missing evidence. Alina says, whereas here, the nature of the alleged breach of a discovery obligation is the non-production of the evidence, where they don't produce the evidence, the district court has broad remedies to decide the sanction. Now, this is a defamation action, and the ongoing trial here is centered around her claims for damages. A significant component of her claims is directly from the death threats that allegedly she got. She said this during her testimony. She said, my brain just froze. So to make myself feel good, I went to my Ask Eugene website thinking that I'd feel better if I could read some support. Now, and I opened it up, and yes, there was a really lovely email, saying, you go girl, yeah. And then I opened up the next email, the next Ask Eugene letter, and I looked at it and I read it and I ducked, because the image of what that person said caused me to believe that it was going to happen right now. I thought I was going to get shot. And what the hard part was, I couldn't get the curtain across the window closed. I was sitting in a room with an open window at 11:30 at night. When you see the words, the image comes into my mind that I believed it was happening right now. So I deleted the message to protect myself. She's like crazy, man. Like, I don't know what the image was. If there was an image, I think she is saying I read an email. I opened up the next letter because the image of what the person said, so it was like a written thing. So they wrote something and I thought it was going to happen right now. So it popped an image into her head. And so she's so deluded that she thinks it's happening. I think I'm going to get shot. Why? Because someone sent you an email? Weirdo. So do you also think that somebody is attacking you in a dressing room at Bergdorf's, like when you watch an episode of Law and Order or something? Because that happened in that show. She's like almost, unwell, just coming up with these images in my mind. When you see the words, the images come into my mind. People just pop stuff in there. I believed it was happening right now. Wow, so you're like crazy. You just like make up stuff like, is Mr. Bergdorf in this room right now, Eugene? Where is he? Is he touching you right now? Is the dressing room door here too? So I deleted the messages. Now, as stated above, Eugene recounted to the jury that she received vicious death threats on June 21st, which she directly attributed to Trump. And so she thought and she sought to substantiate her claim for emotional harm by describing how she felt like an attack would happen right now. Her heart would race. However, it cannot be established that those messages even exist because she deleted them. Now, even assuming that the messages did exist, the question of when they were sent is material and pertinent to Trump's defense. Now, one of the consistent themes throughout this trial has been the causal link between Trump's statements and the damages that went to her. Now, there was a 5-hour window between the time that the cut article from her was posted and the time when Trump issued his first denial. He doesn't even know about it. Media asked. I never heard about it. Plaintiff claims to have received at least 2 death threats on that same date, but she deleted those. Now, then she said that she did not recall what time the messages were sent to her. So we don't know if someone read the article and heard the news and sent them, or someone heard Trump and sent them, because we can't know because she deleted the evidence. And since the messages have been deleted, this information is unknowable. So we have no idea. Now, critically, Alina says if the June 21st death threats had been issued during that 5-hour window before Trump even ever spoke about her, it would conclusively establish that they're not the cause of Trump. That would undercut any of her arguments. And since they say she was receiving similar messages in the immediate aftermath of the article, so it didn't come from Trump. In sum, it's clear from the testimony set forth above that Ms. Carroll sought to circumvent the rules of procedure. She not only failed to preserve her evidence, but instead knowingly deleted the messages that contain the threats. This is a procedural irregularity that is not only appropriate for the court to grant a mistrial, but it's actually essential. Her failure to preserve this evidence in contravention of the rules severely prejudices Trump and his defense, as he's been deprived of critical information necessary for his defense. And so we ask that you declare a mistrial. Now, Now, all of these damages should also be precluded. Anything that's related to her death threats claim should not even be considered for damages. Here's some more from the trial. Miss Carroll, says Alina, when was the first time that you publicly revealed that you received death threats? First time publicly. At the trial, at the last trial in May. Were you also receiving death threats, Miss Carroll? Yes. I'm confused. You stated in your testimony today that you received death threats daily, right? Not daily, but often. So all your death threats that you received that frightened you, they were in writing. Is that correct? Yes. So 4 examples of those, right? Now, as set forth in multiple transcripts, she's testified about death threats on multiple occasions. Her receipt of these messages is a significant portion of her entire claim. Yet, while she claims that she did receive numerous threats, she did not provide any specific testimony about any of the purported threats, with the exception of those she claimed to have gotten on June 21st that she subsequently deleted. And so during cross-examination, she admitted there was a 5-hour gap in between the time that the cut was released and the time that Trump made his statements. Habba says, that was not my question, Miss Carroll. Now, there was a time when you put out the article, the cut article, and when President Trump made his statement, there was a time between those two incidents, right? Right. And if I told you that was about 5 hours, would that sound about right? She admits, yes. So it's undisputed that there were malicious tweets directed at her during this 5-hour period and when Trump made his statement. Now, as explained above, there also a substantial likelihood that the death threats that she received on June 21st, that she referenced in her testimony that's a part of her claim for emotional harm, they were also sent during the 5-hour window. And so if that is the case, then her entire claim for emotional harm is undermined because it would show that she got death threats before Trump said anything. And therefore, she cannot establish a causal link between the death threats and Trump's statements and prove that it was from Trump and not the magazine. Also, E. Jean admitted to knowingly and repeatedly deleting email messages that contained the threats. Delete this, delete that. Plaintiff further admitted that all the death threats that frightened her were sent in writing. And since she clearly failed to preserve the evidence about which she complains today, we can't see whether the contents actually mirrored Trump's statement. They said, well, it sounds like Trump. Well, did it? We don't know. We can't read it. As such, due to the deletion of this evidence, we can't suggest a causal link. And so accordingly, for the foregoing reasons, we request that anything that comes from damages about the death threats alleged, all is precluded. Now, in the alternative, if you're not going to dismiss her claims, we want an adverse inference instruction. So you tell the juries that she deleted the evidence. Tell them that she was in sole possession of the death threats and she intentionally deleted them. Put in there that this was relevant to Trump's claims and now he can't make a defense about causation. And so permit an adverse inference, punish her for deleting the evidence. So add a jury charge to the jury instructions that they may draw a negative inference against her deleting the evidence about which she claims is so damaging. Alina says, for the reasons above, we want a mistrial. And we also want that she be precluded from seeking damages about the death threats. And if you don't declare a mistrial and dump this, then the court include an adverse inference when the case is handed off to the jury so that they know that she violated her discovery obligations and she spoiled the relevant evidence. Great motion from the one and only Alina Habba in the House. And so we're very much looking forward to the judge denying this on all accounts, just to be perfectly clear where this is going to go. Judge is going to say, no. It's all close enough. It's all relevant for damages. The deletion was not relevant. There's plenty of evidence here they've already provided, and that it's close enough, essentially, is what we'll see. And the judge will concoct a reason for it. So we'll be here continuing to cover this. We'll see what happens when Judge Kaplan responds to this. She's going to oppose a mistrial, and then Alina will, of course, get a ruling from the courts. We'll be here as it continues to go down. Trump is scheduled for a possibility to testify when the trial is back in session on Monday. We'll be here continuing to cover this, my friends. Thank you for subscribing and sharing this video wherever it is you're watching this. Thanks for checking out robertgovea.com. Link is down in the description below. Of course, that's where you can find the PDF that we just read. That's where you can sign up for our daily newsletter, and we'll look forward to seeing you there and back here on the next one.